Now I am going to introduce Kim Thorne. He has 42 years experience, board certified and AV rated attorney. His practice is in Grand Prairie, tried over 200 jury trials, extensive practice in wills and probate, real estate, civil litigation, commercial transactions. Now I am inviting Kim Thorne and speak about the wills and estate planning today.
Thank you. It's an honor to be invited to speak to this group, and I can tell from the introduction at the beginning by GS and the explanation of your goals, what you are doing in your community. It's similar to the way I feel about the privilege I have to be a lawyer. It was Ben Franklin that said that doing public service is not like doing a favor, but it's more like repaying a debt. And that's the way I feel, and I think that this group shares that. So we're repaying a debt. I want to take the advantage that I have of my experience and share with you and hopefully give you some ideas. I'm going to talk about simple things, the basics of estate planning. What you have learned from David's presentation and Mahesh and Sam is that there's two things that are inevitable. You've all heard this: death and taxes. Death and taxes. So we're all going to need at some point in time, I think everyone here is ambitious. You're in an entrepreneurial association. The goals here that you have are to make money, save money, build a foundation for providing security for your families. And so that's what we need to do with estate planning. That's the whole idea. It's not for necessarily us, but it's for our families. My father was a lawyer, and I loved him. I loved having the opportunity as a child to go to his office. And there were 9 kids in my family. He had 9 children, and we all trampled his office. So I don't know how he got any work done. But the thing that I always saw on his shelf was a little Art Deco sign that I always wondered, why has he got this sign on his desk and kept it? Now this sign is 60 years old or older. Have you made your will? Only when I started practicing and realized practicing in a community, and I've had the really great opportunity to practice in my hometown in Grand Prairie. So if you haven't had to move around, and it's great that we're in a mobile society, but living in one community, knowing what used to happen here, knowing the families, knowing the generations, and when you get my age, you do know the different generations. And one thing that I've come to realize is every single person needs to do estate planning. Everybody needs a will, and that's why he had that sign in his office. I want to talk about the will. I'm going to cover the mechanics, the basics of wills and probate. A lot of you have already been through this process. Maybe you've had to go through even the probate process for a parent, and you're familiar with this. And by the way, I do want to hit on the topics that interest you. This isn't for me. Raise your hand if you've got a question. We'll try to liven this up and talk about what you want to talk about. But the first thing I want to say is there are some assets that you have that are not included in your will. They're part of your planning. But the things that David talked about and that Mahesh and Sam touched on, A life insurance policy. You have designated a beneficiary in your life insurance policy. An IRA or a retirement account. You have designated a beneficiary for that account. You may have a joint account with a financial institution, typically a joint account with a spouse, in which you have signed a signature card saying that this account is a joint account payable on death to the survivor. If you have 2 people on the account or 3, and you have this payable on death feature, that account is payable just like your life insurance to the person who is the survivor. So those types of accounts you've already provided for transition on death. At your death, those accounts are going to go to the person or persons that you have already designated. So you don't need a will for those things. Your will is for the residue of your estate, what's left. All right, what is the property that will be considered in the will? That's your estate. Now, we are all gentlemen in this room. And I hate to tell you, gentlemen, but in Texas, we have community property law. And our spouses own half of what we have gathered as community property. So we have to consider the spouses. And in fact, when we do our planning and sign our wills, your wife needs a will just as bad as you do, because you have to be protected with respect to what's going to happen to her estate. We have to get that together. So we have a community property law. What is community property? Community property is everything that you acquire after you marry. That's pretty simple. Pretty much everything. Now, what is separate property? Separate property is the other kind of property. Separate property is what you own before marriage, what you inherit through someone's death, whether they have a will or not, but you are an heir and you receive property, and what you receive as a specific gift to you. That's all that separate property is. Now, so your estate, and the same thing applies to your spouse. Your estate is your 1/2 of the community property and your separate property. That's what you have in your estate that's going to pass at the time of your death. Now, what happens to your property if you don't have a will? If you have no will, then we have a probate code, a set of laws that specifically addresses the issue of estates of deceased persons. And the courts call them decedents. Decedents are the deceased persons. If there is no will, there makes a difference whether the person's estate is community property or separate property. If it's community property and the person has a spouse, and out of that marriage there are children, then everything goes to the spouse. Everything goes to the spouse. If there are no children, everything goes to the spouse. If a person dies and with no spouse but children, everything goes to the children. If there are no children, it goes to the parents. Now, the one thing that may or may not apply in this group is that if there is no will and there's community property for a married couple, say the husband dies, but the children are of mixed marriages. If the husband who dies has children from a previous marriage, then the wife inherits nothing from him. She only keeps her 1/2 of the estate, and his children divide, however many children he has, divide his 1/2 of the estate. So that may or may not be the way we wanted to plan it. Now, there is one other concept that, and I'm not going to pass out a pad for a test after this, so you don't have to worry about remembering everything. Some of this detail may be too much, but I'm going to move on to other things. But something that's very important to remember is, in Texas, spouses, the surviving spouse is protected by what's called homestead rights. So when a spouse dies, let's say, I'll say the husband, our ladies outlive us, if the husband dies, there is no will, even though his part of the property may go to children and she only owns 1/2, she has the right to remain in the home and use the contents of the home for the rest of her life. That's her homestead rights. The right to keep a roof over her head. So that's one of those different kinds of concepts, a homestead right. All right, so that's what happens if there is no will. Now, that's what happens to the property, but how do we get the property to whomever is going to inherit? We have to go through a probate court. A probate court is a court that's set up to govern the laws relating to estates of deceased persons, mentally incompetent persons, and minors. So if we don't have a will, then the court is going to appoint someone to be the personal representative of the estate. Now, if you have a will, and we're going to talk about this in a minute, you typically would appoint an executor. You've probably all heard of an executor. That's your personal representative to carry out the terms of the will. But if you have no will, obviously, the court has to appoint someone that they call an administrator. And it's much more complex, much more expensive. And the court supervises every action that's taken with respect to that estate. So that is one of the main ideas of having a will, is so that you can appoint your own executor and make that executor free of court supervision. And I'll tell you that in Texas, probate with the properly named executor is a very easy concept. Has anyone been through probating a will? Wow. Nobody yet. Okay, it's a young group.
Not there yet.
You're lucky. Pardon?
Not there yet.
There you go. All right. Well, it's one of those things. We'll all be going through the probate court, and I hope you find it, as I suggested, it is an easy process. It really is. Now, so let's talk about the situation of we followed my father's advice, and we saw that sign, and we decided let's make a will. What is a will? Will is a written document that expresses how you want your property to be transferred at death. You can think of it like a deed. When you buy property, let's say real estate or even personal property, you get a bill of sale or you get a deed. Well, a will is like a deed, only it takes effect when you die. It's called a testamentary instrument, or testamentary means it takes effect at death. A will can be very simple or it can be complex. We can, lawyers charge by the word, so we like to make it complex. But it can be very simple. I probated a will that was a 2-line instrument written on the back of an envelope. That will said, at my death, I leave all of my estate to my wife. And it was signed. That was good enough for a will. Now, it didn't appoint a personal representative. We didn't have an executor, and there were a lot of other complications. But that will was accepted by a judge as a valid will. So a will expresses your desire with respect to your testamentary intent.